Are you Sherry Johnson? Ms. Johnson, you're charged with making a false report to a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 19th, 2025, at approximately 1:56 p.m., the officer was dispatched to a child custody dispute at a residence in Harris County, Texas. The officer made contact with the defendant's husband, who requested a report be completed because the defendant did not meet him at a scheduled time and location. The officer made contact with the defendant at 4:45 p.m. via the phone, and the defendant was advised about the husband's request for a report. The defendant became upset and stated she was going to call the defendant's probation officer and say what she needed to say to get his probation revoked and serve 2 to 10 years in prison. The defendant stated she had video footage of the husband assaulting her last month on the phone, and she was going to call and have a deputy come to the residence to pursue charges because he completed the report. At approximately 5:37 p.m., the defendant made a family assault call, and the call slip stated, "See reportee," in reference to the husband cussing and pushed reportee. The officer, who had previously contacted the defendant, arrived at the family assault call at approximately 6:02 p.m. and made contact with the defendant. The defendant stated the husband pushed her on 2 separate occasions in January 2025, and the defendant then stated the husband did not punch or push her. He merely brushed against her and admitted it was not intentional. The officer asked to see the video the defendant stated she had. The defendant denied making that statement, and the defendant then admitted to making the statement and stated she did not have a video, but the daughter was present. The defendant stated she did not feel pain, did not have visible injuries, and wanted to pursue charges. The defendant then attempted to change statements again, stating she never made a call for service. The officer read the call slip, and the defendant stated dispatch did not hear her correctly, and that was not what she meant to say. The defendant further denied making a statement regarding the husband's probation. The officer replayed a body-worn camera video of the defendant's statement while on the phone, and the defendant admitted she was not telling the truth.
Ma'am, I'm going to find if there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? That is the gentleman in this case. If I find that you have contact with this person, I'm going to revoke your bond. Look, I can provide you a lawyer today. You can explain your side to the lawyer, but I've got a bunch of DAs here. Anything you say, they're going to try to use it against you to prove guilt. Just don't. I will give you a lawyer. Just explain your side to the lawyer, and then they can go talk to the DAs on your behalf. But I don't want you to say something where you put your proverbial foot in your mouth, you know? Don't. Just. So what I'm going to do is I'm going to have you sign a receipt of Victoria. I will have you then take a seat in the jury box. I'm going to find you a lawyer, and then you can explain your side to the lawyer. Okay? Let me see one thing real quick. I need you to fill an application for me, though. Do you mind? She's going to give you an application. I need you to fill it out, and then I'll have you talk to someone here momentarily. No. Miss Carolyn Price, ma'am, you were charged with assault. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 20th, 2025, the officer arrived at the complainant's apartment due to a disturbance call, and the complainant asked the defendant to leave her apartment after a verbal argument. The child was present, and the defendant then pushed the complainant, leading to further argument. The defendant, instead of the complainant, landed at least one with her right hand, which were also holding a pair of keys. The keys scratched the complainant's face, leaving red marks. The complainant then held the defendant on the floor to stop her from punching her until she calmed down, at which time the defendant proceeded to spit in the complainant's face. The complainant then let the defendant up and told her to leave. The complainant stated her pain level was about a 3 out of 10, and the officer observed the complainant to have 2 red scratches on her cheek.
This is the complaining witness to Ms. Price, please.
Your Honor, the complaining witness is mother of the grandchild, mother of her grandson.
Ms. Price, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you not to have contact with this person. I'm also ordering you not to be in possession of any weapons as well. Did you need a lawyer today? Ma'am? Okay. I will appoint you a lawyer. For now, I'll have you sign a receipt with Victoria. We'll have you take your seat in the jury box. Do not leave until you sign our bond conditions. Then I'll have you speak to the lawyer here. Okay, please. You are Ms. Tovar Martinez. Do you speak English?
Yes.
Okay, ma'am, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 20th, 2025, the officer, a certified DRE, was dispatched to the scene of a wreck at a parking lot in Harris County, Texas. The defendant had been refused entry to a bar at the location due to appearing visibly drunk by the staff. A witness stated the defendant was not walking straight and had a hard time standing. The officer observed the defendant trying to back up from the scene of the wreck when he made a stop. The defendant had watery eyes, a strong odor of alcoholic beverage, and furthermore, the defendant was not making any sense when describing what had transpired to the officers. The defendant was transported to Pasadena jail, where Miranda was read and SFSTs were performed. HGN 6 out of 6. Walk and turn. The defendant took 15 steps instead of 9 and missed every heel to toe. And the one leg stand, the defendant used arms and swayed. The DIC was read and the defendant consented to breath. The results were 0.212 and 0.217.
And Ms. Tovar Martinez, I'm going to find that there's probable cause to go forward with your case. Did you see if she has a valid license, please?
I'll run it right now.
I am now placing a restriction on your license, ma'am. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If I find that you drive a vehicle that doesn't have one, I'm going to revoke your bond, put you in jail. No more PR bonds. I am also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using anything illegal, likewise, you will go to jail. No more PR bonds for you, ma'am.
Your Honor, we have no license on file.
You do not have a license, then no driving. Do you understand? You will be signing an affidavit with me today, promising you're not going to drive, and I don't care what is going on in your life. Do not drive. Since I'm ordering you not to drive, you will get a handheld interlock device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol, man. I'm sending notice to DPS in Austin that every single officer in the state will know that if you get pulled over, you're supposed to have an interlock in your car. So if you're caught driving a vehicle that doesn't have one, they're going to put you in jail. Do you understand? Would you like a lawyer today, ma'am? Okay, so for now, what I'm going to do is I'm going to have you go to Victoria, sign a reset. You will get with Fleischer for bond conditions, and then I'll have you take a seat in the jury box while we try to find you a lawyer, man. Okay. See,
Right this way.
no, I have one already.
Yes.
We're good. So ma'am, it looks like your lawyer was involved in an accident this morning, so he's not going to be here. So what we'll do is we're going to do probable cause. After that, we'll just give you a normal reset. They called us to advise you to call the office, and then you guys can get together with them, okay? So ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes.
Okay.
On January 19th, 2025, the officer was dispatched to a target in regard to a theft. The officer made contact with the complainant, a loss prevention employee, who stated she observed the defendant walking inside the store, grab a shopping cart, select numerous items, place the items inside the basket, and conceal cosmetic items, food, and office items inside her purse. The defendant headed to the register where she only paid for the items in her basket before exiting the store and passing all points of sale. The total was $111.28.
All right, Ms. Saldana, I'm going to find that there's probable cause to go forward with your case. Where is this from again?
Target, yeah.
Target. I'm ordering you as a condition of your bond. Target. Do you understand?
Yes.
If you violate this condition or if you pick up a new case, a warrant for your arrest will be issued. No more PR bonds, man. So can you file that, please?
Yes, Judge.
I'm going to have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and after that, you'll be free to go. Okay? So Danuna was in an accident this morning, I guess, so he's not going to be here. So we'll just do a regular reset, just do, I guess, 30, 45 days. And then she needs state's conditions. Francisco Hernandez, come up.
And Judge, she's in high school, 17-year-old. That's why I wanted to make sure I came with him.
Absolutely. Happy to do it.
Thank you.
Good morning, Mr. Hernandez. Mr. Hernandez, you're charged with evading arrest or detention. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 19th, 2025, at approximately 11:17 p.m., the officer was dispatched to a discharge of a firearm call on Tilbury Woods Lane. Multiple calls stated there were multiple gunshots in the area, and while servicing the area, the officers were flagged down by a citizen who stated she heard multiple gunshots and a green sedan sped off. Multiple citizens provided video footage, and the officer saw a vehicle that matches the description parked illegally in front of a residence on Moss Springs Court Road, and multiple males exited the vehicle. The officer then initiated a traffic stop, and the driver and passengers began evading on foot. Officer ran after all three males for 100 yards, and all were detained by the officer. The defendant and others admitted they saw emergency equipment and decided to evade on foot. Surveillance video showed the defendant throwing an AR pistol with no serial number in front of the residence, and surveillance video matched the defendant's clothing.
Saying our defendant here was seen throwing an AR?
Allow me to read the DIMS to confirm that it is.
Sure. They filed a tampering. Am I right in assuming that that's the serial number?
Yes, Judge, it is this defendant throwing the AR, and the firearm had no serial number. Yes.
How can you impute the tampering because it's a specific intent crime, right? Unless you have an admission or something like that, something that I have. But you know what? That's not even my forte.
Yes, Judge.
It's like we're doing the evading right here. So
Fighting upstairs, gonna
I
fight
gotcha.
down here too. So you can already expect my issues with this case already.
no, you're 17. You're now starting your life. This is not a good way to start. You know, you only have two ways that you can go. You can go up or you can go down. Life doesn't get easier the older you get. It only gets more difficult. You get bigger, fatter, you lose hair. It doesn't get easier. And it starts with school. Stay in school. Don't hang with dogs. You're going to get fleas. Do you understand? Mr. Hernandez, you are not to smoke weed. You're not to use alcohol. And I'm making that a condition of your bond. I don't want you to have any possession of any weapons as well. Do you understand? If I find that you're in possession of a weapon, I'm going to revoke your bond. I'm going to put you in jail. You're going to finish school with me. You understand? Did they impose any other kind of restrictions up there as far as like curfew or anything like that?
They did not. At first, he had an ankle monitor with the curfew. I asked the court, they agreed to take it off. So his mother and him are gonna go after this court proceeding to get that removed.
Is mom here?
Mom is here outside with his younger sister.
Okay. Make good decisions, man. Once you start racking up convictions, I'm telling you, it's over. It's not going to get easier. You understand? We've given you a lawyer. It is your responsibility to stay in touch with her. She's great. She will help you out. If you're not listening to her, you take off. I can't find you. You pick up a new case. I'm going to put you in jail. No more PR bonds for you. Do you understand? One more thing. I will test you in about 45 to 50 days. And if I find that you're smoking weed, it's not going to go well for you. Do you understand? You will get tested. Be ready. So I don't care what you're doing. If you stop using, if you stop doing anything that you shouldn't be doing now, then you should be fine in 45 to 50 days. But if you continue to use, or if you smoke, it's not going to go well. You understand? Okay.
Thank you.
Thank you so much for coming. We got you. And then anything you need, whatever you need, just come back and we're happy to help.
Thank you, Judge. And just one thing real quick with the state. I know there's other people that were in this vehicle allegedly. Do you have any names for them? Can you,
I can see.
if I circle back around from you?
Oh, co-defendants? That's a good, because you know what?
And that's part of my issue with both of these cases.
And Your Honor, it does not appear there's any connected cases.
So I have,
So
yeah, that's my issue with the tampering. That's my issue with this case.
They got them all, right?
That's what they say.
Maybe just because of the surveillance shows allegedly one being thrown and that's why they only went after. Perhaps, I don't know. But
I won't fight everybody too crazy today, but probably the next day. Yeah.
I'm with you. You know, whatever you need, just
Thank you, guys.
make good decisions. That's all we're asking you to do. All right?
Thank
Okay,
you very
guys,
much.
thanks. You got it. So, Mr. Hernandez, do not leave because we need you to meet with pretrial, okay?